Good day, everyone. My name is Saloshna Pekari. I am the head of the Deceased Estate Department at Jan Jordaan Attorneys. Today, we have Jan Jordaan discussing some important facts regarding deceased estate transfers. Over to you, Jan.
All right, good day. Today is the 17th of February, 2021. It is the first seminar for 2021. Can you believe it? Last year's first seminar in February, we did not know what was waiting for us for the rest of the year. Hopefully next year, this time, we will all be meeting at Benoni Country Club again and socialize again and have something to eat and drink and have a proper seminar. But for now, a Zoom video is the only way to go. Anyway, today's topic is all about deceased estate property transfers. What is a deceased estate property transfer compared to a normal transfer? First of all, a normal transfer is where you facilitate the sale between a seller and a purchaser. It's registered in the deeds office, and that's your normal transfer. A deceased estate property transfer is when you sell a property out of a deceased estate. That's when the person has passed on, and his estate is then administered in terms of the Administration of Estates Act. It is different to a normal estate, and that's what we're going to discuss. The question I always get is, how long will that take? Our standard answer is always a normal transfer takes anything between 6 and 8 weeks. Deceased estate transfer in a perfect world should not take longer than 2 to 4 weeks, or should not take longer than an extra 2 to 4 weeks compared to a normal transfer. And I'll explain that to you just now why it takes a bit longer. But with a huge big but, we're dealing with the Master of the High Court, and at this stage, as we speak, they really behind with their work, and it's really a challenge to get certain documents from the Master of the High Court. In some instances, we're waiting literally months to get the documents from them. The main issue in the Master's office is that they can't always find their files. But be that as it may, we have a dedicated staff member that goes to the Master's office in Johannesburg twice a week and once a week to Pretoria to sort all these problems out. So we deal with them. So let's start. Deceased estate transfers. I'm going to share a few documents with you, and we can discuss it, or I'll discuss it as we go along. First of all, very important to know is that a nominated executor cannot sign an agreement unless he has been appointed by the Master. So understand the difference. In a will, and I'll show you the typical clause in a will, you are, or somebody is nominated as an executor. Let me show you quickly. Please bear with me. There you see, that's a typical paragraph where we nominate Jan L Jordaan Attorneys to be the executor in our estate. Right. So that's the nomination. If there's no will and it's an interstate estate, then the heirs will get together and they will nominate somebody. In this instance, the estate late Peter Allen nominated myself, or I'm being nominated by the heirs, and on that basis, the Master of the High Court will appoint me as the executor. Right. Only once you're appointed as the executor can you sign a sale agreement. Also, only once you're appointed as the executor can you sign a mandate. People, it's very important. If you sign an agreement before you've been appointed as the executor, that agreement is null and void. The nominated executor do not or does not have the authority to sign a sale agreement unless he's been appointed by the Master of the High Court. All right, the next thing is the executor gets appointed by the Master of the High Court, and this is how an letter of executorship looks like. The stamp is very, very important. As you can see on the right bottom, this will stamp on the 7th of October 2019. That's the date that you would refer to in an agreement or in your transfer documents. Once the letter of executorship has been issued, then you can sign a sale agreement. Now, this is typically how you will cite an executor. I used my name here, Jan Jordaan, in my capacity as the executor in the estate of the late Joe Soap, duly authorized thereto by virtue of a letter of executorship. All right. Then, now we have to get the consent from the master for the sale of the agreement. All right, so remember always in your agreement to make it subject to the consent of the master. There's a certain document, a certain format how you do it. We complete a J33. Let me show you quickly. A JM33. That's the application form that we complete with the property description, with a few questions on the left-hand side, asking if there's a will, if the estate is insolvent or not, etc., etc. The executor will sign that. So this is your JM33. With that, you have to send a copy of the sale agreement to the master. You have to get the consent from all the heirs to the sale. Now, the purpose of that for the consent is that the heirs need to know about the sale and they need to consent to it as well. Now, the question always arises, what happens if all the heirs don't consent to the sale of the agreement? I'm going to read from my notes. It says, if no consensus is reached by the heirs to sell the property from the estate, the executor may apply to the Master of the High Court by way of Section 47 for the sale of the property without the consent of the heirs. You, as the executor, need to obviously inform and convince the master why he should give his consent without the consent of the heirs. A typical thing is where you have to sell a property to cover debt. Another reason is where the heirs are fighting about how the estate should be wound up. There's various reasons why we need to could or should make use of Section 47 of the Administration of State Act. But anyway, the long and short is it can be done. And so when we send the documents to the master with the consent from the heirs, we also have to send the power of attorney that we prepare. So in this instance, you can see it's the power of attorney where I, in my capacity as the executor, give consent that the property may be transferred into the purchaser's name. Now, this consent has to be endorsed by the master in terms of Section 42(2). So at the back of this power of attorney, the master would put a stamp. I hereby certify in terms of Section 42(2), Act 66 of 1965, that there is no objection to the transfer as stated herein, signed by the master and dated. All right. Now, to get this endorsement back from the master is where the challenge comes in and where where a lot of time is wasted. as I said, in a perfect world, it shouldn't take longer than 2 weeks. In fact, it shouldn't take longer than a few minutes. But be that as it may, at this stage, we're really waiting a long time to get it back. That is one of the challenges that we have, and but we get to that. That's part of what we do. So the next question is there transfer duty payable? Now, why the question is asked is because when you inherit the property, there's no estate duty payable. The attorney or the conveyancer who is attending to the transfer still gets paid, but there's no estate or transfer duty rather payable, right? But when you buy a property from a deceased estate, there's definitely still transfer duty payable, right? The next question that we often get is, what happens to the proceeds of the sale? When you wind up an estate, one of the very first things that you as an executor has to do is, once you're appointed as the executor, is to open a bank account. Now, the purpose of this whole bank account is any monies that you receive during the administration of the estate is to pay the money into that account. At one stage, when you finalize the estate, you have to prove to the master what you received and what you're paying out. Now, the proceeds of a sale will be paid into this estate account. And once the liquidation distribution agreement has been approved by the master and is laid in for inspection for 21 days, only then can the money be paid out. Please feel free, if there are any questions about deceased estate transfers, my personal email will appear on the screen now, Jan L Jordaan. Don't hesitate to send me an email, ask any question. Our telephone number will also appear on the screen now. Please shout if there's anything, we can help you with anything. Yeah, thank you for listening. I hope this is informative, and please remember to be a blessing and be kind to others for no specific reason. Thank you. Enjoy your day.